justice is going to have to prevail. The courts are not going to allow this practice to continue in which these companies can hurt kids with impunity. When you are on social media, you are not the customer, you are the product. They are selling you. They're selling your eyes, they're selling your engagement to advertisers. And they keep you online not by showing you what you want to see, but by showing you what you can't look away from.
Welcome to a special edition of the John and Mark podcast. Today we're joined by the founder of the Social Media Victims Law Center, Matt Bergman, who I've known for about 4 years since he originated this social media addiction litigation. We're here in Los Angeles at the beginning of the social media addiction trial. We had Snap and TikTok settle out a couple weeks ago. We've still got Meta and Google who are still participating in the trial. Today was the opening arguments from YouTube and the beginning of the plaintiff's experts. Matt, thank you so much for joining us. We really appreciate it.
It's good to be here.
Matt, for those who don't understand what this litigation is actually about, can you help explain to them, what is it actually that the claims are against Meta and Google?
The claims are that they have designed social media products to be addictive to kids, that they've done so knowing that their platforms cause severe mental health harm or worse to kids. They keep doing it because they make their money selling advertising to kids. And if kids suffer, so be it. That is the business rationale that these companies have followed, and the reason why for the last 4 years I've been chasing this white whale.
When you started this back in late 2021, did you ever think it would get to where we are today?
Yeah, but that's just because I'm a plaintiff's lawyer and I'm optimistic by nature. And I just felt like when I learned about what these social media companies are doing to kids, how they have exploited Section 230 to avoid the kind of responsibility that every other company in America follows, I just thought at some point justice is going to have to prevail. The courts are not going to allow this practice to continue in which these companies can hurt kids with impunity.
How did you conceptualize this from a concept to going up against the traditional 230 claims and then eventually bringing it to where it is today?
Well, I was a asbestos plaintiff's lawyer for almost 30 years.
And a damn good one. For those of you that don't know Matt's history prior to this.
I learned a lot, and I learned how product liability can be adapted to changing technologies and changing legal theories. And I understood and learned through some victories and some spectacular defeats how to overcome legal obstacles on behalf of meritorious plaintiffs, and that if you keep working and fighting hard enough, at some point the legal system will yield to the cries of justice. So as I learned about social media and the carnage that it is continuing to inflict on vulnerable kids, as we heard from early whistleblowers about the conscious disregard that these companies have for basic principles of safety and social responsibility, I thought that I'd apply my experience as a product liability lawyer in devising a legal strategy that would get past Section 230, which theretofore had prevented plaintiffs from even getting started in trying to hold these companies accountable.
The judge gave some pretty explicit instructions a few days ago to the jury about this case not being about the content of what is on these platforms, but about the product itself. Do you think that that message was heard by the jury? Do you think they understand it, that it's not really about what is actually on the video or the photo, but it's about the product itself?
You know, I have found that juries listen very carefully to court's instructions and generally try very hard to follow them. I think that it is a challenging distinction because the harms in many cases emanate from content as a direct result, but content is fed to kids through defective algorithms and dangerous products. You know, I think that there will be a lot of needle threading throughout this trial. The court is going to work very hard. The lawyers are going to work very hard. But, you know, we are all plowing new ground legally. I think that inevitably these issues are going to have to be resolved at the appellate level, and that all, plaintiffs and defendants in the court are doing their best to establish a coherent and logical frame of reference for the courts of appeal to ultimately determine how these companies are held accountable and for what.
If the content that was portrayed on these platforms was all teddy bears and Bible verses and warm hugs, but the products still existed the way that they exist today, how would that change the narrative, or would it not?
Well, it depends. The platforms are designed to be addictive, and they are addictive by utilizing operant conditioning and artificial intelligence to identify the things that trigger the greatest dopamine response in young people. And if some people's dopamine response is triggered by teddy bears and moonbeams, and they spend 8, 9, 10, 11 hours a day online when they, at the expense of their social development, their intellectual development, their physical health, then that is a problem. And addiction in and of itself is a harm. Unfortunately, we know that what kids are fed is not teddy bears and moonbeams. It's suicidal content, telling them to walk in front of trains or take shotguns and shoot their heads off, or engage in eating disorders or horrific and reckless challenges. And they do that because what triggers the dopamine response is material that is discordant, typically. And in order to maintain the dopamine level, the platforms as designed have to show kids more and more extreme material to get the same dopamine response, to attain the same level of engagement, to be able to sell the same level of advertising, to make the same amount of money.
At their core, what is the business model of these platforms?
When you are on social media, you are not the customer, you are the product. They are selling you. They're selling your eyes, they're selling your engagement to advertisers. Based on the sophisticated technology, they are able to provide advertisers with highly targeted opportunities to address the exact demographic group, the exact cultural group, the exact customer that they're looking for. But the more they can keep you online, the more money they make because they sell the most advertising. And they keep you online not by showing you what you want to see, but by showing you what you can't look away from. They keep you online by utilizing gamification through endless scrolls and likes and streaks and other features that are designed to exploit the need for social acclaim that adolescents have and to keep them engaged long after they want to stop and go to bed or do something else.
We were riding the elevator up to the studio and you were telling me about today you had your addiction expert who was speaking in court. What are some of the things that they pointed out that would make the common person gasp about the addiction that these platforms are actually enabling?
And this was Dr. Anna Lemke, a psychiatrist who's head of the addiction medicine program at Stanford University, author of the very prominent bestseller, Dopamine Nation. It's been translated into 35 different languages. And Dr. Lemke talked about a couple things that I think was unusual for people. One is that a social media addiction has the same neurologic components as other forms of addiction, like alcohol or tobacco or drugs, that it affects the dopamine response in the brain in the same way, that susceptibility to a social media addiction is universal across all kids, whether they be kids that have had a troubled upbringing or a pristine upbringing, but that kids who are troubled, either through the OSES or through family challenges, are more susceptible to addiction, that there's a bilineal relationship between mental health harms and mental health vulnerability and social media addiction, that they are mutually reinforcing of each other. And finally, that these platforms do not exist in their present form by accident, but rather by design, that the psychological principles of operant conditioning, the neurologic principles of dopamine extraction have been self-consciously incorporated into the design of the social media platforms to make them addictive by design and by intent.
How could there even be a defense against that?
First and foremost, there's Section 230, a statute enacted in 1996 when Netscape, if any of you remember, was the largest browser in the world, when Google didn't exist, when there was no social media, and when Mark Zuckerberg was in junior high. And that statute was designed to make it easier for companies to protect kids and to ensure that the nascent internet was allowed to develop. Unfortunately, it was interpreted far beyond either its statutory language or legislative intent. At a time when there was a real social narrative that social media was a great thing, that it was going to bring people together, that it was a communication thing, and that these companies were really great companies founded in people's garages. And the legal rubric took on this hagiographic view of social media that is clearly belied by its current incarnation. But first and foremost, the companies say, we're immune. We can do whatever we want. So you had court opinions involving kids that were sexually trafficked, minors who were sexually trafficked on Backpage. And the court said, well, that's because it's a social media platform, it's immune from any regulation. People who were bullied, people who were sent in very dangerous directions or connected with predators. And again, time and time again, the early holdings were that those were immune. So in answer to your question, how do they justify it? They say, we can do whatever we want. We're immune. They have some other excuses that they make as well once they get over their hurdle. But it's eminently clear to me, and I say this after having had access 2 years of discovery to all of the internal documents of these companies, that you really don't see much concern about liability. You see in these companies a lot of individuals of conscience who are saying, gee, what are we doing to kids? Why are we doing this? Our platforms are dangerous. We should change it. And in time and again, ultimately, when the decision comes down to safety or engagement, i.e. profit, they always pick profit.
Is that from the top down?
It is from the top down, literally. You know, when Aturjo Behar sends a memorandum to Mark Zuckerberg saying 1/3 of youth every week receive sexually explicit content, unwanted sexual content from adults, and the decision is made not to change the notification features or not to change the public by default features. Yes, they are made from the top down. This is not an accident. And what is particularly tragic is that these safety improvements could be easily implemented by these companies with minimal effort in a week. This is not a question of a product that has inherent danger. Some things are just inherently dangerous. That's not true for social media. You could make social media 80% safer with well-known, easily implementable changes that could take place in a matter of days.
What are some of those things?
Turn off the algorithms. Show kids what they want to see, not what they look away from. Does that mean that some kids are going to go online and find some bad stuff? Sure. That also means that a young woman who's interested in diet is not going to be force-fed material promoting emaciated bodies and anorexic behavior. A young African-American man interested in music is not going to be put down rabbit holes promoting gang violence. An individual who is looking for affirming content after suffering a breakup is not sent suicidal content. All this stuff could be done if the platform simply wanted to focus on the quality of the online experience as opposed to the level and extent of engagement. Easy. Another change would be agent identity verification. Make sure that people are who they say they are, so that you don't have a 47-year-old pedophile posing as a 13-year-old boy trying to convince another 13-year-old girl to provide revealing pictures of herself. If adults want to hook up on Tinder, they got to provide identity verification. They prove you are who you say you are. So why don't we provide kids with the same level of protection as we do adults who are looking to hook up? Limiting the time. Kids are online all hours of the day and night. Kids receive push notifications at 3 a.m. We know that, first and foremost, any more than 2 hours a day of social media is diverting kids from other more productive activities. We know that sleep deprivation is in and of itself a cause of mental health and physical distress. So limit the hours. Don't hook up people and strangers. If someone wants to actually become your friend, make sure they're someone you actually know or someone you actually are connected with, as opposed to relying on the need for social acclimation that young people have. And finally, provide basic warnings. Provide parents and kids with a sane appreciation of the risks that they're undertaking when they go online. Those simple changes wouldn't solve all the problems, but we wouldn't be here today if they'd made them.
Matt, do you think the shifting laws internationally preventing children, in Australia, I think it's under the age of 16?
Yeah.
Right? Do you think that is an approach that could potentially work in the United States?
I think 16 is too young. I think 18 is a better age. But yes, kids are most vulnerable at their early prepubescent ages. And certainly in the cases that we have seen, the most extreme versions and examples of social media addiction take place among kids who get online very, very young. Also, banning the cell phones in schools has had a great impact. I mean, just ask any school teacher.
You've become the architect of this new phase of mass torts that are targeting technology platforms in a way that attorneys used to target pharmaceuticals, drugs, medical devices. And we've seen the onset of litigations like Roblox. Do you see the same parallels between the Roblox litigation, which has just recently been consolidated, and what you're dealing with here in the social media addiction litigation?
Absolutely. We have a number of Roblox cases in the MDL, which we may seek to transfer now that there's a consolidated proceeding. But yes, it's a somewhat similar phenomenon. I think that each platform has its own particular dangers. Roblox in particular purports to be a platform for little kids, and yet it provides a vehicle for pedophiles to connect with them. And we've had a number of those cases. But, I think what you see as a new technology develops, there's good and there's bad to the technology. And what the civil justice system is supposed to do when it's working is instill in companies the economic incentives to design and produce and sell safe products as opposed to dangerous products. So this is not a question of stifling technological development. This is simply an exercise in what an economist would say, internalizing the cost of safety.
What do you think is going to happen tomorrow when Mosseri is on the stand and next week when Zuckerberg's on the stand?
Well, we are very fortunate that our trial lawyer, Mark Lanier, is the foremost trial lawyer in America. I think his record speaks for himself. I think that they will be held and called to answer for their conduct and their documents. And unlike when they testify in Congress, the questioner doesn't have to stop at 5 minutes and pass the baton just when things are getting good. This is a historic moment, and I really want to stress that for me, the fact that we have the opportunity to present our case to a fair and impartial jury is in and of itself a tremendous victory. I've tried enough cases to know that you don't win them all. And juries appropriately hold the plaintiffs to their burden of proof. But for so long, families have been deprived of that basic right, the basic opportunity to present their case to a jury and let the chips fall where they may. That's all we're trying to do.
The Social Media Victims Law Center brand that you created has become synonymous with this litigation in many ways and has continued to evolve. So you've had lawsuits against other platforms that have resolved. Outside of what we're dealing with here today, if you look at what happened in Australia, there was an immediate spike to alternative platforms as soon as the ones that got banned were locked down. Now that subsided, and then people moved to VPNs and they're trying to access the platforms from outside Australia. There's all these sort of circumventions. What do you think the next thing is that parents need to keep their eyes on outside of the known harms that we're aware of today?
Well, the AI chatbots are clearly dangerous to kids, and we have, over the last year, ventured into that litigation. We recently secured a consolidation of the ChatGPT litigation and are looking at other AI chatbots. So I think that's a clear and present danger to kids. Gambling, we're seeing as a particular danger, particularly for young men.
The prediction markets have just exploded over the past
Yeah.
6 months.
It was never easy to be a parent. It certainly was never easy to be a parent of a teenager. I think it's a really challenging time to the extent that parents first and foremost lead by example and not be on their phones all the time.
It's hard.
It's hard.
Really hard.
We all, yeah. I mean, I think we need to try to the extent possible, restore what Professor John Haidt calls a play-based childhood versus a screen-based childhood. Parents need to encourage their kids to put down their phones and to go outside and play, or to engage and play with board games, or put models together, go out on a date, go outside, go ride their bikes. I mean, we have become, on one hand, so overprotective of kids, while at the same time exposing them to risks and dangers that are orders of magnitude greater than anything they'd face in the quote-unquote real world.
Just because they're still visible in front of you doesn't mean the things that they're looking at on their devices are any more safe than the harms that they can get outside their front door.
Right. We're afraid that if we let our kid go outside and play, that their kid's going to be molested. And the fact that, a pedophile in Nigeria can be sextorting your child while that child is in the next room, a number of cases leading to suicidal outcomes, is incongruous, but is really the real risk that kids face. To some extent, it's societal. I think that, the polarization that we're experiencing is somewhat a product of that. And so I think we need to get back to, as parents, encouraging kids to have more human relationships, more face-to-face relationships, more unstructured playtime, more risk-taking, and less time online.
There are cases going on now in parallel to this one. You've got the cases from the school districts and from the individual state attorney generals that are against the social media platforms. How do those differ, if at all, from this MDL?
The school district and the state AG cases are encompassed within the federal MDL. The first cases that are going to go to trial in the federal MDL are going to be state cases this spring. They rely on a similar legal theory, and they rely on a similar nucleus of tortious conduct, that being the intentional design of unreasonably dangerous platforms. But the harms alleged are very different. And so I think it's different types of harms inflicted on different types of populations from the same underlying misconduct.
How long do you think this has been going on with these platforms? Was there an inflection point where they made the decision that now we're really going to focus on profit over safety, or has this just been inherent in the platform since their origination?
It looks like it was not inherent from the origination, particularly like with YouTube. They went from a model when they wanted to expand to a billion hours of use per day. It wasn't right away. And if you want to give them the benefit of the doubt, and I'm not sure I do, but if you do, you could say, well, they weren't quite aware how these algorithms work. There's some truth to that. I mean, it really is like a black box. Once they saw what their platforms were doing, they had, as you say, an inflection point. You can make a decision to make it safer, or you can make a decision to keep reaping the enormous profits that you're making through these effective designs. Sadly, they chose the latter.
If you go back and rewatch The Social Network, or kind of think about the timeline of Facebook's evolution from Harvard dorm room to now facing you in court, at some point Facebook went public. I think of that as like just mentally, now your responsibility is not to the users of your platform. Now your responsibility is to your shareholders. And that, to me, regardless of when these things actually came out in public or when they were documented, now they are responsible to their quarterly reports. They're responsible to their fiscal year profitability, and they're responsible to their shareholders and making sure they're continuing to grow their valuation year over year over year. That is just an inherent conflict of interest, isn't it?
I don't think so. I think it's a little different than that. I don't believe these are companies in that sense. In a mature company, you have shareholders that hire and fire a board of directors that hires and fires a CEO, a general counsel with a fiduciary duty to speak the truth to the board of directors. These companies, for the most part, aren't function that way. Mark Zuckerberg owns 58% of the voting stock of Meta. The two founders of Snapchat own 98% of the voting stock. So you don't have kind of the normal checks and balances that a mature corporation has. Look, I am pro-capitalist. There is nothing wrong and there's a lot right with companies making good products and making good money and making profits for their shareholders. I'm all for that. But what I'm against is when you have this skewed liability framework where the rules of the game that every other company has to follow are not applied to social media, not applied to high tech. That's where the problem lies. It's not the profit motive. And also where you don't have the kind of maturity of a company with the typical checks and balances that a company has, where you have one or two or three people that are basically the board, the CEO, and the general counsel all wrapped in one. That's not the way corporate structures are supposed to be. The corporate form has a very important role in our capitalist system, but this is a perversion of that role. This is what an economist would call an externality, because the costs of these platforms are not borne by the social costs, and the economic costs are not borne by the platform and by the company itself. And the skewed deviation from capitalism as we know it and capitalism as it exists in democratic societies such as ours.
What do you want to say to attorneys who are thinking about the next thing that they come up with? You had this idea, you board this litigation. If they come up with a concept, how do they take that concept and appropriately vet it to determine whether or not it can become even close to what you were able to do with your concept of the social media addiction?
I think you got to believe it, as we'd say in Yiddish, in your kishkas. It's not about thinking of the next new thing or the next way to make money as a lawyer. I mean, we might make money doing this, we might not. But it's about when you have this epiphany of injustice and a path forward to alleviate it. I always regretted that I was too young to have been a civil rights lawyer in Mississippi in the 60s. I find in this work the same moral clarity that existed in the civil rights movement and in the civil rights cases. And just as when you had a legal system that subjugated people of color to deprivation and discrimination and humiliation, having to drink out of separate drinking fountains or ride in the back of buses. And you said, how can a legal system tolerate that? How can that be constitutional? How am I going to figure out how to change that? Well, when you have a system where companies can send suicidal videos to a 16-year-old boy telling him to jump in front of a train, and he jumps in front of a train and his parents are bereft of any legal remedy. And the company said, sorry, your son died, but we're not responsible. To me, that has the same moral clarity and the same clarion call that a legal system cannot abide providing that level of immunity, providing that kind of injustice to exist. So I would tell people, instead of looking for what's the next great class action, what's the next great thing to be able to deploy your legal talent. And I would say that when your sense of justice is so offended by what you see, when the righteousness of your clients is so clearly juxtaposed against the malevolence of your opponents, then you know you've got something. It might turn into something huge, it might not, but at least you'll have honored your oath as a lawyer and practiced law at its most essential and rewarding and meaningful level.
Give me chills, Matt. I think we are at the precipice of a real change, and you are the engine that is pushing that forward. And I thank you as a father for everything that you're doing to help push that forward and enact change in our society and make sure that this place that we all call home is a little bit safer for the next generation. Thank you everybody for watching. This is this very special edition of the John and Mark podcast with Matt Bergman. Trial continues tomorrow.